So imagine for a second that you have quasi-union protection at your job, but you've never paid any union dues, not a cent. And if you get fired, you can legally demand your job back.
It sounds like a loophole, doesn't it?
It really does, but for thousands of Canadians, this is just the reality of the law.
It is. It's a pretty unique privilege in our employment system. We're actually digging into some insights on this from HTW Law.
Oh, right. They were on the 2026 legal power list.
That's them. And their analysis really helps decode these specific, powerful rights for what are called federally regulated employees.
Right.
It's all under the Canada Labor Code.
And that's the key distinction, right? Because most of us, the vast majority, we're operating under provincial laws.
Exactly. The Employment Standards Act.
Where, if an employer wants you gone, they write a check for severance, and that's usually the end of the story.
That is the standard, yes. But the Canada Labor Code, or the CLC, it creates a completely different world, a whole other ecosystem.
And we're looking at a specific part of it, I believe.
We are. Division 14th, specifically sections 240 to 247. It's all about unjust dismissal.
Okay, unjust dismissal. And this is where the power balance really shifts.
Dramatically. Because this isn't just about getting a payout.
It's about the job itself.
Exactly. If you're a non-manager and you've been there for at least 12 months, the remedies are, well, they're incredibly powerful. An adjudicator can actually order the employer to bring you back.
With back pay?
With full back pay. It's something you almost never see in provincial law. This is why HTW law calls it quasi-union protection. The employer can't just buy you out anymore.
Wow. That completely changes the risk for a company. They can't just treat severance as like a business expense.
They can't. They have to prove the dismissal was justified on its merits. And the bar for that justification is incredibly high.
Is there a legal precedent for this?
There is. The big one is a Supreme Court case, Wilson v. Atomic Energy of Canada, Ltd.
Okay.
And that case basically cemented the idea that federal employers have a duty to apply what's called progressive discipline.
Meaning they can't just jump straight to firing you for a mistake.
That's it. They have to show a paper trail. Trying to correct the behavior first. We're talking verbal warnings, written warnings, coaching.
So they have to prove they tried to make it work.
They do. If they skip those steps and just fire someone, an adjudicator is very likely to overturn it. It forces a non-union employer to act like a union shop.
So who does this apply to? It's obviously not the local coffee shop.
No, not at all. The best way to think about it is it's the infrastructure layer of the country.
The things that connect us.
Precisely. Banking is the huge one.
CIBC, RBC, all of them.
Yep. Then you've got telecommunications, so your Rogers and Bell employees. After that, it's air transportation, railways, grain elevators, even uranium mining and First Nation activities.
So if your job involves the flow of money, data, or goods across the country, chances are you fall under this.
That's a good rule of thumb. But that flow of goods part can get legally complicated, especially with trucking.
Right, because everything depends on where the trucks are actually going, doesn't it?
It's a very fact-specific legal test. HTW law has a great example. Say you have a local trucking company that only operates within one province.
Okay, so they're provincially regulated.
Correct. But then they expand. They start running a regular route across a provincial border.
Uh-oh.
Well, the very nature of their business has just shifted. They might have just accidentally graduated their entire workforce from provincial to federal regulation.
So a simple business decision to add a new route could rewrite the employment contracts for the whole company without them even realizing it.
It happens more often than people think. But, and this is critical, there's a kind of trapdoor here for the employee.
A time limit.
A very unforgiving one. You have exactly 90 days from the day you were dismissed to file a complaint.
Not 3 months.
90
days.
If you miss that strict deadline, the right is just gone. The jurisdiction evaporates.
And the law is clear. You can't be forced to sign these rights away in an employment contract, but you can absolutely lose them by just waiting too long.
That's it. Section 168 prevents opting out, but the clock forces your hand.
It's such a fascinating part of our legal system. You have this invisible line where one person has standard job security and the person next to them has this superpower, just because of the industry they're in.
It really creates a dual-class system of rights, and it leaves us with, I think, a really provocative thought, especially for any entrepreneurs listening.
What's that?
If your local business is growing and you're looking to expand across that provincial border, are you prepared for the moment your growth strategy accidentally gives your entire staff federal-level job security overnight?
Definitely something to check before you route that first truck. Thanks for joining us on this deep dive.